This program is called It's the Most Wonderful Time of the Year, and generally for litigators, it is the most wonderful time of the year because courts generally don't schedule trials around Thanksgiving, Christmas, Hanukkah, New Year's. If you ever want to see a ghost town, go to the Cuyahoga County Court of Common Pleas between Christmas and New Year's. Having said that, my first trial this year started January 2nd, so it wasn't necessarily the most wonderful time of the year for me this year. What it is the most wonderful time of the year for you to do, and what I can help you doing, is reviewing purchase and sale agreements, whether you're in the business of selling goods, services, real estate, what have you. Everybody in this room sells something and buys other things. And by reviewing the contracts that you use to govern the terms of those transactions, you can really help yourself if you're in a dispute and end up having to come see somebody like me. Brian alluded to part of a saying, an ounce of prevention is worth a pound of cure. I can tell you that in 99.9% of the matters that I'm handling in a litigation context, the things that we're arguing about, if they had been spelled out more clearly in an agreement, would have, if not avoided the dispute, certainly have streamlined it. Now, granted, you can't plan for everything. It's easy to Monday morning quarterback, especially if it's the Cleveland Browns and you don't even know who the quarterback is going to be on Sunday. But there are certain things that you could put in your agreements just to have some certainty. When you're a seller, well, let's look at when you're a plaintiff and you come to me and you want to collect money from somebody who owes you money, there's certain things that you could have in your agreement to make that process more palatable. Because my job when I represent plaintiffs is to, well, my job is when I represent anybody, is to get you to a resolution of your dispute as quickly and as cost effectively as possible. That applies across the board. But when you're looking to collect money from somebody, my goal is to make you whole or as close to whole as possible. So in terms of reviewing your purchase and sale agreements, there's certain provisions that you could put in there to make that more likely. The first thing is providing for interest. Let's take a $50,000 dispute. If one of you comes to me and says, Joe Blow owes me $50,000, I want you to sue him and collect that money. If there is no provision in there that you're getting interest on that money or attorney's fees, which is the second bullet point, it's going to be virtually impossible for me to make you whole because you're going to be paying me out of that pot that you're seeking to collect. One of the ways, or two of the ways, to avoid that problem is to include an interest provision in your agreement. And a lot of times you'll see, and we can go to the next slide, man. A lot of times you'll see on an invoice just interest due on past due accounts at 1.5% per month or 18% per year. I could tell you that if that is just in an invoice and it's not acknowledged or signed by the party you're seeking to enforce that against, generally courts will not enforce that. So if you want to collect interest, put it in your agreement and saying interest on past due accounts shall accrue at X% per month or Y% per annum. And if it's a signed agreement, courts will enforce it. I remember the good old days where the Ohio statutory prejudgment interest rate was 10%, so this wasn't as important. And I think everybody would agree that 10% return on money that's owed to you is a pretty good deal these days. But for the last several years, Ohio ties their interest rate to, I think it's a short-term treasury rate, and they announce it October of every year. Right now it's 3%. So as a matter of contract law, you can get prejudgment interest in Ohio at 3%. But if you put something in your agreements that provides for a better rate when you're a plaintiff seeking to get money, that will make it more likely than not that I, as your lawyer to get you what you're owed, can make you whole, or certainly closer to whole than you would be if that provision wasn't in there. Attorney fee provisions. In America, we have the American rule, which is each side pays its lawyer unless there is some statutory basis or contractual basis for fee shifting. In most cases, you can provide that if you have to sue on your agreement, not only do they owe you what is due and owing under the contract, but they are liable for your attorney's fees. That's enforceable in most cases. Now courts are going to imply a reasonableness. You can't just run the meter incessantly and wastefully. But again, if you are a person who is seeking recovery for amounts due and owing, if you have an attorney fee provision, knowing that the other side is not only on the hook for what they owe you, not only on the hook for their own attorney's fees, but also potentially on the hook for your attorney's fees, that in many, many cases will facilitate a quicker resolution of a dispute. I could tell you, you all know that attorneys are expensive. I can tell you that it's more and more common these cases where it's not so much the merits of the case that will resolve a dispute, but the cost of either pursuing the dispute or the cost of defending it. So if you have those fee shifting provisions in it, and you know that, both as a plaintiff or a defendant, that a lot of times will facilitate a resolution. I have a case right now which involves a complaint under a lease where I'm defending it. I can tell you that the merits of the claim are, to use a non-legal lease term, BS. The problem is this particular lease, which we didn't draft, does not have a fee shifting provision, and it is going to cost more for my client to litigate the dispute than to go to court and prove it's right. If that fee shifting provision had been in there, we might take a different tack and say, well, we're going to go to the mat with these guys, and not only are we not going to owe them what they're claiming we owe them, but they're going to pay our attorney's fees. So it's really something that you want to look at and put in your purchase and sale agreements. Forum selection clauses. Generally, you can say in your agreements that if there is any dispute, here's where we're going to adjudicate that dispute. And as long as there's some reasonable relationship to where you pick and where the transaction occurs, courts will enforce that. I tell my clients, I like the home games. I like to litigate disputes in Cuyahoga County or Northeast Ohio. I have a case right now where there is a forum selection clause in the contract which you're disputing, which says that all disputes arising under the parties' agreement shall be determined in the courts of Washington County, which is Marietta, Ohio. That's a 3-hour drive for me and my client. And, that's time, and time is money. So if you want to make it a home game, and there's some reasonable basis for including those types of provisions, you can provide that all disputes shall be adjudicated in the courts of Cuyahoga County. We actually have in our fee agreements, which many of you have seen, that disputes are determined in the Bedford Municipal Court or the courts of Cuyahoga County. It's enforceable. You could put those provisions in your agreements. Jury trial waivers are also enforceable. If you are going to go to court, I can tell you that a jury trial is way more expensive and way more time consuming than a non-jury trial. So if you are going to go to court, you may want to consider putting a jury trial waiver, which is even more palatable now in Cuyahoga County, for example, because we have a commercial docket. I handle commercial litigation, and there's a select few judges, and they're expanding it in 2015, but there's a select few judges that specialize in commercial disputes, and they're generally skilled in commercial disputes and will handle them fairly and cost effectively. So if you're going to go to court and you don't want the time and expense of a jury, you could put a jury waiver provision, and those are generally enforceable. There's also mediation or arbitration provisions that you could put in your agreements. I am a big fan of alternative dispute resolution. I think mediation is terrific, and you generally can't force parties to mediate unless you put it in a contract. The nice thing about mediation is nobody can impose a decision upon you, whether you're the plaintiff or the defendant, that you don't agree to. And so it's a good process, and I encourage people to put it in their agreements. Arbitration used to be a very low-cost alternative to litigation. I'm not sure that's so true anymore, but it's still something to consider if you want to stay out of court. The nice thing about arbitration is once a decision is made by either an arbitrator or a panel of arbitrators, it's relatively non-appealable and final. So where it still does maintain its cost effectiveness is that once you get a decision, you're done and you're not looking at appeals. So it's also something to consider. I'm a big fan personally of mediation. Arbitration, I can take it or leave it, because a lot of the cost-effective tools in arbitration have gone out the window because arbitrators, you pay for arbitrators' time. A lot of the discovery that usually was by the wayside, went by the wayside in arbitration, has kind of crept back in. So it's something to think about, and if you want to talk about the pros and cons of an arbitration provision in an agreement, you can call me or someone else at our firm. Some of these other things, and I think we're a little time crunched, but obviously if you're looking to collect money in terms of security, there's personal guarantees and mortgage or security interests. Obviously, it makes no sense to throw good money after bad, and if you're chasing an entity that is judgment-proof, and you can't go through the pierce the corporate veil argument, which is a very difficult burden to meet, even if you don't have good records, and I'm not suggesting you don't have good records, but it's still a high burden. It's nice to have a personal guarantee, or at least a mortgage or security interest to provide some security for the debt that you're going after. Disclaimer of warranties and limitation of remedies and exclusion of damages. Those are things, the UCC, which Article 2, which governs this purchase and sale of goods, those are things that are governed, that are statutory, but certainly when you're selling goods, you can disclaim warranties, such as the warranty of merchantability and fitness for a particular purpose. You could limit remedies, saying the only thing that we're obligated to do is repair or replace any defective goods. You could exclude damages such as consequential damages or lost profits. You basically want to make the realm of uncertainty as small as possible and the sphere of certainty as large as possible. The battle of the forms, I'm not going to, because we're pressed for time, I'm not going to get into that as much, but basically what that is it kind of dovetails what Scott was talking about, where you have a series of email communications going back and forth. This is when you have the quotation, purchase order, and there's conflicting terms, and there's things that we can do both on the seller side and the buyer side to make sure that you know what terms are part of your agreement, which are not. Because if the terms are different, you're going to get into a big argument as to which terms govern. And for example, that form selection clause in Washington County that I was talking about, that was in a battle of the forms case where we're arguing about whether it's in the contract or not. When payment terms are different. One term might say payable within 30 days. One might have well, you're only going to get paid if my customer pays me. Obviously, those are conflicting terms that you want to avoid, so you know what the terms and conditions of your agreement are. Once again, an ounce of prevention is worth a pound of cure, and if you at year end, or any time, but especially at year end, look at your purchase and sale agreements and put these types of provisions in, and put some certainty and make what it could be, what it would otherwise be gray, more black and white. It will not only help you, but it will help us if you have to come to us to either collect money from somebody or on the defense side, avoid paying to somebody. Thanks.